Sorry, there's some programs in the front for those of you who don't have a program. Just put up your hand and I'll get one to you. Thank you, Dean LaPiana. Now we will move into our program. We're at 9:15 now, so this will go to 10 o'clock.
Good morning. My name is Kirk Burkhalter. I am a professor of law and Dean of the Evening Student Engagement here at New York Law School. And it's my pleasure to introduce our keynote speaker, after which our panel will provide responses, and then our keynote speaker would be happy to reply to those responses, should he so wish. So it's my pleasure to introduce Mario Barnes. Mario Barnes is the Chancellor Professor of Law and the Director of the Center of Law, Equity, and Race at the University of California, Irvine. He also served as the Tony Rembe Dean and Professor of Law at the University of Washington School of Law, from 2018 to 2021. He is currently, as Penny mentioned, the president of the Law and Society Association. Professor Barnes is a nationally recognized scholar for his research on the legal and social implications of race and gender, primarily in the areas of employment, education, criminal, and military law. At UC Irvine, he teaches criminal law, constitutional law, national security law, and race and the law. He is one of the leaders and organizers within the Law School of academics seeking to build stronger connections between empirical studies and critical race theory. He writes and teaches in the areas of criminal law, constitutional law, national security law, and race and the law. At UC Irvine, Professor Barnes has taught the inaugural class of 2009 and was instrumental in developing the law school's curriculum and sense of community. Additionally, he served as the second Senior Associate Dean for Academic Affairs, the first Senior Associate Dean for Faculty Development and Research, and also helped launch the Center on Law, Race, and Equity. Before joining UC Irvine, he was a faculty member at the University of Miami Law School, where he was twice elected as Outstanding Professor. And prior to that, he was a William H. Hastings Fellow at the University of Wisconsin Law School. Prior to his academic career, Professor Barnes spent 12 years on active duty in the United States Navy, including service as a prosecutor, defense counsel, special counsel, assistant to the United States Attorney, and on the commission that investigated the 2000 bombing of the USS Cole in Lemon. His reserve assignments have included service within the Naval Mine and Anti-Submarine Warfare Command in San Diego, the Navy Inspector General's Office in Washington, D.C., and U.S. Special Operations Command in Tampa. He retired from the United States Navy in 2013 after 23 years of service of combined and reserved service. Professor Barnes earned both a bachelor's degree and a JD from University of California, Berkeley, and an LLM from the University of Wisconsin. He is the founder and managing editor and co-editor-in-chief of the African American Law and Policy Report, now the Berkeley Journal of African American Law and Policy. Professor Barnes is a fellow of the American Bar Foundation, an elected member of the American Law Institute, and a distinguished fellow of the National Institute of Military Justice. He received the NYLS Ferguson Award in 2015 and was honored with the NYLS Derek A. Bell Jr. Award in 2008. I had the pleasure to meet Professor Barnes a couple of years ago when a few of us would travel to Johannesburg, South Africa, where once again he delivered a keynote address during a dinner there. And his remarks were insightful as they were dynamic and extremely well received. So I very much look forward to his remarks today. So without further ado, Professor Barnes. Thank you.
Next, I'm just going to submit. I am Mario Barnes. I teach at First of all, I want to thank my dear friend Penny for corralling me into this. Mostly because she knows one of my number one rules, like most people's, is we cannot say no. So thank you so much. I also want to to say something that one of the things of that conference in South Africa was the word Ubuntu, which is I am because we are. And I would slightly change it. I am because you were here first, and that includes a number of people. Penny, Ken Shepperly, Frank Munger, all of whom are past presidents of the Law and Society Association, who I've known for over 20 years, who have been incredibly supportive in my journey. He thinks he's escaped, but Heinz Klug as well, who was on the faculty at Wisconsin when I came back as a graduate student in 2002, which was essentially one of the pre-university University of Wisconsin. So I am deeply grateful to all of you for the investment you have made in bringing me into the for what has been an amazing second career for me. So I also know to you one of the very few times because the invitation was to like, think about the impact of the work of Jack Balkin, and the expectation in these kinds of environments is that we often that something would praise, but then offer some particular criticism, and not just like with Jack Balkin, I really specific number in significant issues, but in looking at his work on constitutional practice and law, I found a path into which I thought I could both provide a sort of commentary that honors the work, but also asks questions about what it means in this particular involvement. So, as you might imagine, my lens, or sort of related to this, comes from teaching constitutional law, writing constitutional law, mostly related about protection and due process, but in a former life and in a former career, I concentrated a lot on it. And so, at the sense of thinking about is there not executive power at the center? And so, I was spend a little bit of time talking about executive power as an introduction into questions that I often define through and then ask more inquiries about it in this particular moment. And so, the idea of a constitutional breakdown of the separation of power that's on executive power certainly not new. We have many instances of this, which many of us teach about. Famously, I think most of us still teach Youngstown Sheet and 2 versus Sawyer, which asks questions about whether the president enjoys inherent authority in any particular context, but we certainly all teach also modern examples where we question whether the president is acting with constitutional or statutory authority. And if I just go back a few presidencies, we can talk about Bill Clinton in 1999 ordering airstrikes against the Federal Republic of Yugoslavia, which is the subject of the case Campbell versus Clinton, where he did so after there was a deadlock on a House vote, which did not approve those strikes. We have George W. Bush in the terrorism surveillance program, which appeared to contravene the Foreign Intelligence Surveillance Act. It became the subject of ACO versus NSA. We had Joe Biden's attempt to cancel loan debt, which became the subject of Biden versus Nebraska. And in the first Trump administration, there was Trump versus Hawaii, dealing with the travel bans under the INA, and then also Sierra Club versus Trump, which was repurposing of military funds for the border wall, and most recently in this term, we had learning resources versus Trump dealing with the executive directed tariffs. And so there are always these questions of the existence or expanse of executive power, and those questions don't necessarily ever lead to broader questions of crisis or wrong. So in some ways, these things have been historically repeat player initiatives where presidents are first actors, or presume at least initially to take some action where we don't know necessarily whether there is a true separation of powers issue. But what was different on the precipice of the first Trump administration was a question as to if, in fact, we end up with a situation where the president acts, and there is an order from a court, and like in all of the cases I just mentioned, detailing whether in fact that was consistent or in opposition to the existing constitutional framework. The question that many of us ran our hands over in 2016 was whether the president would follow a judicial order. Look, I'm not that old, I'm happily in my mid-50s, but certainly in my lifetime of teaching, that had not been a question, right? This notion of whether, in fact, there could be an order from a federal court or the Supreme Court for which the president would not comply. And so at the time in which Jack Balkin writes this article, this is the background. Right? He's writing this in 2016 and 17. And there are real questions about whether so much about what has led up to the election of Donald Trump and certainly what takes place in the beginning of the first term is so unusual and unorthodox and not like things we have seen before. So even though it seems peculiar that we might be asking whether the president actually disobey the law, this is occupying the sort of intellectual space of constitutional commentators. And so when Jack publishes Constitutional Crisis and Constitutional Right and the Maryland Law Review in 2017, he basically sets out for us a distinction between what he defines as a constitutional crisis, which we normally would think of as a moment in which the president fails to observe the rule of law or defies a judicial order, versus a broader and larger context of something I will define based on or provide based on his definition as constitutional right. And so, and what he says at the beginning of this is, well, we actually are not in a moment of constitutional crisis, at least not early in the first Trump administration. But we were, in fact, according to him, in a more extended period of constitutional decay. One in which our norms for fair play and threats to our democracy were on the table, which is far from perfecting. So I'll begin by sort of setting up Professor Balkin's framing, tell you a little bit more about what he says crisis and rock are, and then ask my query. So we start from the place actually of what he doesn't quite define, but I'll say is either what we might think of as the constitutional status quo, right? This idea that the Constitution is operating to its central purpose, keeping the peace, keeping people committed to operating within a politically discursive space rather than outside of it, and balancing the roles among the government and between the state and the polity. And so, the whole point is constitutional crisis and rock to serve this status. As far as what he calls crisis, it's broader than this normal sort of question of do we have a moment where the president who is defying judicial order or a threat to the rule of law. He says constitutional crisis should be thought of in broader terms as occurring when there is a serious danger that the Constitution is about to fail at the essential task of keeping disagreement within the boundaries of ordinary politics, rather than breaking down into anarchy, violence, or civil war. As an example, he gives, he claims that a constitutional crisis would have resulted had President Nixon refused the Supreme Court order to turn over the Watergate case. So he defines it in some ways as inclusive of the notion of disobeying judicial order in terms of disrupting our understanding of what I might call the status quo. He goes on to say, crisis typically arises in three contexts. One, political leaders refuse to obey the Constitution. The Constitution keeps political actors from preventing homeland disaster. Or three, lots of people just refuse to follow the Constitution. To me, that's revolution, or if any of you are old, Doobie Brothers fans, take it into the streets. So we will not be held down by the order engine. So, and so, to the extent we were worried about this, he said, and Trump won, at least that time in 2017, it had not come to pass that there were repeated and rampant violations or threats to produce constitutional crisis. He says that essentially, at some point, we were worried, perhaps, too much that there would be a breakdown of a kind that we were not familiar. But he goes on to say, even though we did not have a crisis of the type we might have expected, that we did have a period, certainly a rot. And in order order to tell you about Rod, I have to tell you about one more concept, which is the ideal of constitutional party. And Balkin tells us that he is borrowing this from Mark Tishman, and Hardball is essentially, I'll just quote it, refers to political actors stretching or defying political conventions that are treated as unspoken rules of fair play. One example of hardball was the Senate's refusal to hold hearings on the nomination of Merrick Garland in the last year of the Trump presidency. In other words, this hardball, he claims, is part of what leads to rot, because people are treating sort of our previous norms regarding political fair play as no longer in any way restricted, and so playing hardball can lead us to where we are moving away from these norms of fair play toward rot, and rot is peculiar, according to him, to places where the constitutions represent representative democracy. So it's not just that rot can occur anytime. If you have a Republican form of government, that is where rot is likely to be an issue. And then it arises when politicians disregard norms of fair political competition, undermine public trust, and repeatedly overreach by using constitutional hardball to rig the system in favor and to keep in their own favor and to keep themselves and their allies in power. And so essentially rot represents the idea that these politically partisan tactics can cause the system of democratic and Republican constitutionalism to decay. And so, in other words, he wasn't so concerned about the episodic or the sort of periodic question about whether the president might defy an order. He was much more concerned that politics had devolved to a place where it was now partisan politics were so polarized that they were threatening the constitutional order. And so hallmarks of rot include a loss of trust in government and our fellow citizens, political polarization, increasing economic inequality, and policy disasters, which are defined as serious failures in decision-making by public representatives that result in a loss of faith in government. And ultimately, if left unchecked, it can lead to oligarchy, demagoguery, and the word that has now been thrown around quite often, authoritarian regime, right? And so this is what happens if we end up with an extended period where essentially the politics of it all start to undermine democracy. Having established this, there was not a question as if to ask, well, is he correct about this, right? I mean, it was clear to me, and in the examples he gave, he provided examples from the first Trump administration saying, it's not, things like, whether he is following a judicial order, it's much more the firing of FBI Director Comey or governing through what Balkin said was strategies of exacerbating the polarization that were the problem, and he saw these as existing, certainly at the initial sort of onset of what I just referred to as Trump administration. And so he sort of seems to be suggesting to us at that point in 2017, there's a far larger problem that we should be concerned with, although, not necessarily providing us with for how you might respond to it, at least in the formation we have, which is one party in power having the ability to essentially deny the ability of the opposition to in any way reframe the debate around the choices that are being made. And so the queries I had about this, well, okay, so if I accept that this is correct, and I do, the real question for me is, well, does this continue into Trump too? I'm going to give you the early sort of answer on this, yes. And then secondarily, more problematically, has rot become normalized? Third, are there things we can do to contextualize the understanding of rot, but give us a deeper insight into it, but also then perhaps give us a way to think about intervening? And then finally, what, if anything, are we to do? And so, on the question of have we continued into Trump 2 or the second term into a period of extended, I merely look at what has happened since January. last year. And I say, well, on the question, I can start where Walt can start. But on the question of crisis, we probably have at least a couple of instances where there could have been questions about crisis, because we do have at least 2 instances where there's at least a claim that federal court orders were not followed, right? And so on the one hand, it involved the order regarding the deportation flights to Venezuela that was not followed, and then there was a second order regarding an order for the administration to release federal funds, I think, for the SNAP program, both in March of last year. And so we have had instances where there has been some defiance. We have not had an extended conversation about whether that means that the crisis is now full blown. But on the question of Rod, I'll just throw out a couple of things that might speak to it. Immigration crackdowns, the blurring of Posse Comitatus, Operation Absolute Resolve, which is the Venezuelan intervention, Operation Southern Spear, which is the narco-terrorism intervention. That one's particularly problematic for me because I actually used to be the lawyer who advised Navy units on drug interdiction, and that mission was called Visit, Board, Search, Seizure, which is you stop boats, you check them for drugs. If they have them, you turn them over to local authorities. If not, you don't shoot them. You certainly don't shoot them attempting to come back onto their vessel. So there's the narco-terrorism incident, there's Operation Epic Fury, which is going on now, as well as questions regarding the dismantling of the civil service, the firing of FTC commissioners, that's before the court now, attacks on DEI in spaces where we presume there was no federal interest, and then a recent threat to assert federal control over local elections. Why did those things all sort of individually and cumulatively speak to deep political polarization that has created economic and democratic instability, right? It certainly speaks to the question of, do these things cause us to lose our faith in government? I suggest yes, and if you agree, then the second administration certainly has carried forward a second period of destabilization that looks like constitutional rot, more so than constitutional crisis. And so, in one way, that was the first sort of point that Balkin made. Then, but the second point to me is, does it matter at all anymore, this kind of difference between constitutional status quo stability, a notion that we could have momentary or a temporal crisis, which is actually the old world entirely, right? Stability and moments of and to this new period of extended decay of constitutional and democratic norms. And the reason I ask if it matters, and this leads to the second inquiry, because these things only matter if you presume that there is a baseline to which we all agree, for which there are understandings about what the accepted norms are for political engagement, and what the general, because we can never say so, the generally understood norms are for the bounds or binding on executive. If you accept that there is a world in which we have norms, at least, for these things, it's fine to speak about a status quo, moments of crisis, and then a period where we might be in rot because of a decay that's undermining these core values. But I don't know anymore if we can get an agreement, at least across political aisles, on an acceptable set of norms that would provide for us some notion of a constitutional order, which we can agree has a baseline for fair play that is being violated by any of the things I just mentioned. And so if you don't have an agreement on an accepted set of norms, if you don't have an agreement on what fair play looks like, then it cannot be said necessarily that there would be agreement that any of this is anything other than what we now might imagine our new reality of politics as usual, which is to say we have just accepted a new form of extreme polarization, one that undermines perhaps democratic or Republican, democratic norms or Republican form of government. But the question is, if we were being honest with ourselves across political ideation and affiliation, could we agree on norms? And the truth is the president alone is not capable of norm setting here, right? We have to have a sort of broader set of interests at the table. And if it was possible to have a moment of honesty, could we agree on what the norms would be, such that we then could decide when it is that the violation produce what Balkin is now calling right. And at bottom, I really question whether our current moment means we can't really talk anymore about crisis and right. It just is our new order, and we will have to figure out whether in fact and how much that places our democracy at risk, whether that's temporary or more long-standing. So a couple more things and then I'll finish. So one of the problems for me is that the article does focus way too much on the how and what, right? And so, what precipitates this, how it's working in the sort of political spectrum. It doesn't focus on who is most affected or the why it's sort of produced in this particular moment. And so one of the things I talk about is, I think there is a way in which this, it's not helpful to think about this as a standalone piece of constitutional and political theory that can be evaluated separate from other disciplines and other theories. As was mentioned, my own work is on at the intersection of empirical methods and critical race theory, and there are certainly critical literatures that speak to evaluating this from a perspective that would ask different questions. Certainly, if you think about the work of someone like Mari Matsuda, who would say the way in which we should evaluate politics should be about how the people at the bottom are treated and look to the bottom to ask how they are being affected and what we should do about the sort of political danger. Kimberly Crenshaw, our colleague and friend who teaches half the year at Columbia, has given us excellent work on cycles of reform and retrenchment. And there is a story here about why we are in this moment of constitutional rot that has to do with the danger of the success of actually becoming a multiracial democracy that was threatened, right? And so in some ways, there is not this conversation that could be had about those kinds of articles. And then there are just like social legal scholars that do great work, both in terms of quantitative and qualitative work that will help us understand when we are actually in a particular kind of positionality and what are the variables that help us to anticipate when we will be there and what it will take to get out of it. But there are also sort of, political and social theory like John Hart Ely that says, in a moment of crisis, it should be the judiciary that works to save our democracy. Not sure that's actually possible anymore, given how the courts are working. One of the comments this week that I really agreed with came from Justice Jackson, who said part of what's going on now is this growth of the shadow docket has created the problem of all of the problems coming very quickly to the Supreme Court, undermining the authority of lower courts, but also meaning our court is pronouncing on every political hot button issue in the moment of it, which can be a part of this, right? You destabilize us by defying our normal order of how we deliberately consider constitutional and political questions. And so there's that. I think the other thing I was going to mention is there are studies that talk about what produces moments of greater polarization, including what are the types of sort of conditions that lead to authoritarianism, right? And so, and I cited some of them, so I won't go on at length. The point is there are other disciplines, there are other stories to be told that are a part of this that exist outside of just the political theory and constitutional theory of this that have to do with the who of it and the why of it. And I think part of, if we're ever going to make any headway, we need to sort of marry these discourses, right? And so finally, I took a shot at, I didn't have anything very good on what do we do about this, right? So, huh?
Darn.
Yeah, no, turns out I'm no Jack Balkin, but no, so here's the thing. There are not a lot of levers, right? And so I stretch my brain to say, is there anything, if what you think about is this is a threat to our sort of, Republican form of government. We in fact have the guarantee clause, which nobody ever teaches except for in Baker versus Carr. Oh, I teach it in Baker. That's the only time. Which says, okay. So the clause mandates that the federal government ensure every state maintain a Republican form of government, but we've never seen any kind of enforcement in our constitutional jurisprudence. In the sentence, could you think of a way in which we could make a real claim that's related to threatening the Republican form? And the answer is, I don't have it. But it's if you're asking for the textual kind of underpinning of a way to approach it, that's what's there. But what I came up with, it's not good, but it's what's there, is the real question is, do we expect the responses to this exceptionally dangerous moment to be themselves within the constitutional order or within the constitutional law? Because it seems to me that we are now in the place where some will start asking, should we consider extra legal measures to what has become a great threat to our form of government? And the answer really is, we don't have great examples of this working, right? I mean, many people think that George W. Bush's actions post 9/11 in response to that great sort of entry to the American psyche and people, a great many of them were, at least in the near term, extra legal, and it was deeply problematic. And there are articles written on this, the emergency constitution, the anti-emergency constitution. Oren Gross has written on this. Should, in times of crisis, we have to observe, limitations? Should we have some ability to have extra legal responses? And if we think about it, the January 10th uprising is an example of an extra legal response to what is believed to be a breakdown in the constitutional order. And so my sense is that is at least a framing that might allow for something other than the devolving into, well, only revolutionists, right? Which is this notion of, is there some understanding of a limited kind of almost a kind of understanding of, we can cabin what would be, at least in the near term, an extra legal response, but one for which it doesn't devolve into revolution. Okay, so I will stop there so that, again, I provided you some notes that have some more additional things that I knew I would run out of time. But the bottom line of this is, yes, we are in this, space of right. Yes, it's threatening to our democracy, but I don't have any kind of, we have a panel on Rotten, maybe not, I don't have any sort of framing that gets us to anything beyond wait until there's an administration change and hope that the damage is not absolute.
Thank you so much for your comments. So I'd like to introduce the folks that are going to provide responses for us. First is Professor Rachel Van Cleve, who is a visiting professor of law at Pacific University McGeorge School of Law, and Professor Rick Marsico, who is a professor of law here at New York Law School, and also the director of the Wilf Impact Center. We have about 11 minutes left, so I will ask you to limit your remarks to 5.5 minutes, because I can only imagine how painful it is to get stabbed with a knitting needle. So, Professor Van Cleve, Professor Marsico, go ahead. We'll start with you. Sure.
Thank you.
You need a microphone?
Oh.
You didn't ask me that.
Yes. Thank you. That was dizzying in a good way. I guess for the first 90% of your presentation, I see Dean LaPiana there. I was going to ask him if maybe he could either take me out of the rotation for con law, because I'm not sure whether there is con law anymore, or whether we should just change it, the name, to constitutional rot. But what really inspired me was your question. I have exclamation mark.
Normalization?
Yeah. Yeah. Who can help with norm setting? And I just think the answer, among others, is us. And in connection with that, I think of Humpty Dumpty. And
I did not see that.
Humpty Dumpty had a great fall, and then sat on the wall. Humpty Dumpty had a great fall. All the king's horses and all the king's men couldn't put Humpty together again. And I think that the process of creating this rot is a long-term process, as Dean LaPiana described. That has, I think, has its roots in perhaps the weaknesses of Article 2 of the Constitution, the lack of clarity with who decides, especially regarding military action, Congress and the president. And it reminds me of there was a Federalist paper, I don't have it in front of me, but where I teach it when I teach executive authority, where Hamilton said, oh, don't worry about the president becoming a tyrant. Look at the powers of the executive in Article 2, compare them with the king. And of England, the king has so much more power, you don't have anything to worry about. And I ask my students, what would you say now? How would you comparing the president to the king? And they constrain the king without a written constitution. And we have a written constitution, and look what's happened over time. So I think the role of creating norms is a long-term effort. I don't think we can put the pieces back together again very quickly. So I try to think of long-term solutions. So long-term, I tell my students on the first day of class, you are ambassadors of the Constitution. You will have to raise your right hand and say, as lawyers, you will uphold the Constitution, and you have to take that very seriously. And I think we all have a role in reestablishing these norms, and so that's sort of my long-term question on what we can do. My short-term is so my kind of specialty field is education law, special education law, public K-12 education, and within minutes, that was all under attack with DOGE. I mean, they tore apart the Department of Education, and in particular, the Office of Civil Rights. And not only did they gut the Office of Civil Rights, but they immediately changed the rules of disparate impact. And we were, in my center, we were investigating, we had a complaint with OCR ready to go that New York City discriminated in its provision of special education on the basis of race. And we didn't file it. So we had to scramble to figure out other alternatives. And I guess just in the short term, because we have a federal democratic republic, there are states. States have laws. State laws are frequently much stronger in their protections. So we look, we look to state law alternatives. And you mentioned you mostly write about equal protection and due process. And in response to San Antonio v. Rodriguez, Justice Brennan wrote this very famous article, let all of your states have a constitutional right to education, focus on states. And it worked. And I'm thinking, that's just one alternative. We still have our states. They have laws. So in the short term, how can we fight this? We can look to other alternatives. But thank you so much for that wonderful presentation.
So early in my career, I wrote a lot about state constitutional law, and I felt like I was, off on the margins in academia. And I also work a lot in comparative law. And again, sort of off on the, there's no there, right? There's no there when it comes to state constitutional law, when it comes to comparative law. And now here we are coming back around to state constitutions. And you mentioned the guarantee clause, and where there were challenges to voter initiatives and things like that. I'm in California. We have a long history this because of all the voter initiatives and challenges under the guarantee clause, and the court wouldn't touch it. I really like the idea of bringing in who's affected by everything that's going on, because so many of the discussions that I've been a part of recently focused on the rule of law. We understand what that means, right? We get that means. I think most people don't really understand that. There's sort of, it comes across as neutral. And I think what people see now is neutral in the sense of both sides are bad. Republicans are bad, Democrats are bad, pox on both their houses. And so that means, you know, people might not be turning out to vote, et cetera. Does it really matter? And so I think that one thing that maybe could be part of this discussion is trying to define more specifically what we mean by the rule of law, and maybe using, you know, how this is impacting people could be one way to do that. I designed and taught a class on the shadow docket this spring. And one of the most challenging pieces of this is the role of the US Supreme Court. I completely agree, because many of my students and I got the impression that the court was allowing things clearly in violation of the Constitution, birthright citizenship, just one of them, allowing those things to happen with impoundment of funds, allowing these things to happen on the idea of the executive just needs to be able to carry out its policies without addressing, well, what if the executive is define the Constitution, right? So I think that a lot, the Supreme Court bears a lot of the responsibility of this. I think the lower courts are really trying to do what they can, and I completely agree that what the court is doing on the shadow docket undermines all of the work of the district courts.
The thought was that that wasn't supposed to be precedential, right? The whole notion, it's certainly changed in the way in which the court even sort of
Yes.
cites the work it does.
Well, yeah, and for Justices Gorsuch and Kavanaugh to sort of chastise a federal district court judge for not following a shadow docket order, which typically doesn't have much in the way of reasoning, is pretty shocking. Yeah, so not supposed to have.
Given the reasoning that Kavanaugh offered in the Perdomo case, perhaps we don't want it.
Truly.
Yeah.
No, truly. Yeah. So from undermining, I do like this distinction between, because so much of the discussion has been, are we in crisis? Are we in crisis? Is this it? Is this the moment? Whereas Rott really looks at long-term and sort of deeper questions and norms. And yeah, where do we look? I mean, I think all of us, yeah.
I am hopeful that in this room,
and today we'll figure it all out.
Suggestions that will help us move this conversation forward.
Yeah, but this was a fantastic beginning to the discussion. Really, thank you so much.